to keep the hearing going as members go back and forth. And as I mentioned yesterday, we welcome all of our friends in the audience and ask that they be quiet and respectful during the hearing. So let's get started with the questioning, and I'll begin at this point. Judge Jackson, there are two issues that came up repeatedly yesterday from the other side of the aisle that I want to address at the outset. One of them was a question of judicial philosophy. No one questions either your academic law school credentials or your service as clerk and as federal judge, but time and again you have been asked, what is your judicial philosophy? Does it fit into Scalia's originalism, Kavanaugh's textualism? Is it strict construction? Is it liberal? Is it conservative? Lo and behold, I've discovered the answer. It turns out that during the course of your time as a judge, you have actually had written opinions, 573 to be exact, I think. Maybe I'm off by one or two. And they more or less express your view of the law as the facts are presented to you in each one of those cases. And then some 12,000 pages from the Sentencing Commission, transcripts of deliberations on important issues. For most of us as elected senators, if people asked, what's your philosophy, we'd point to our voting record. You have a record when it comes to court decisions. And this committee, for the fourth time, is delving into everything that you've published as a judge and even before. So would you like to comment at the outset of those who are looking for a label, what your position is on judicial philosophy?
Yes, thank you, Mr. Chairman. Over the course of my almost decade on the bench, I have developed a methodology that I use in order to ensure that I am ruling impartially and that I am adhering to the limits on my judicial authority. I am acutely aware that as a judge in our system, I have limited power, and I am trying in every case to stay in my lane. And so what I do is I essentially follow three steps. The first step is when I get a case, I ensure that I am proceeding from a position of neutrality. This means that you get a case and it's about something and it's submitted by certain parties. I am clearing my mind of any preconceived notions about how the case might come out. I'm setting aside any personal views. It's very important that judges rule without fear or favor. The second step is once I've cleared the decks, so to speak, in this way, I am able to receive all of the appropriate inputs for the case. That is the parties' arguments. They've written briefs. Sometimes we have a hearing. Sometimes we hear from other parties, amici in a case. And then there's the factual record. I am evaluating all of the facts from various perspectives. I think my experience, all of the various experiences that I've had, really helps me at this stage to see the perspectives of all of the parties and to understand their arguments. And then the third step is the interpretation and application of the law to the facts in the case. And this is where I'm really observing the constraints on my judicial authority. There are many constraints in our system, importantly, because judges have limited authority. And so I am, first of all, looking at my jurisdiction. Threshold matter in every federal case is to make sure that you even have the power to hear the case. In evaluating jurisdiction, you're looking at all sorts of things, the text of a jurisdictional provision, for example, precedent related to it. If I can get to the merits of the case, if I have jurisdiction, then I am observing the limits on my authority concerning the question. So if it is a statute, for example, or a provision of the Constitution, I'm looking at the text. the adherence to text is a constraint on my authority. I'm trying to figure out what those words mean as they were intended by the people who wrote them. So at this point, I'm looking at original documents. I am focusing on the original public meaning because I'm constrained to interpret the text. Sometimes that's enough to resolve the issue in terms of the merits. Judges also look at history and practice at the time of the document was created. If it's a statute, I'm looking at Congress's purposes, because again, I am not importing my personal views or policy preferences. The entire exercise is about trying to understand what those who created this policy or this law intended. I'm also looking at precedent, which is another constraint on judicial authority. I am looking at prior cases and trying to understand what other judges have said. As a lower court judge, I'm bound by the precedent. And even in the Supreme Court, if I was fortunate enough to be confirmed, there's stare decisis, which is a binding kind of principle that the justices look at when they're considering precedents. So all of these things come into play in terms of my judicial philosophy.
Another issue which has come up to my surprise, and I've spoken to my Republican colleagues about their fascination with it, is the notion of the composition of the Supreme Court, which euphemistically is referred to as court packing. I have said on the floor, and I will repeat here, there is exactly one living senator who has effectively changed the size of the Supreme Court. That was the Republican leader, Senator McConnell, who shrank the court to 8 seats for nearly a year in 2016 when he blocked President Obama's nomination of Merrick Garland. Now, that question on court packing was posed to Amy Coney Barrett, Justice in the Court, when she appeared before this committee. She was asked about it. She said, and I quote, "could not opine on it." And on many other policy issues, then Judge Barrett said repeatedly she could not share her views, stating, and I quote, "I will not express a view on a matter of public policy, especially one that is politically controversial, because that is inconsistent with the judicial role." I do believe we should have rules and traditions and precedents, but we shouldn't have a separate set of rules for Republican nominees and Democratic nominees. So Judge Jackson, if a senator were to ask you today about proposals about changing the current size of the Supreme Court, what would your response be?
Senator, I agree with Justice Barrett in her response to that question when she was asked before this committee. Again, my North Star is the consideration of the proper role of a judge in our constitutional scheme. And in my view, judges should not be speaking to political issues, and certainly not a nominee for a position on the Supreme Court. So I agree with Justice Barrett.
Let me address another issue that came up yesterday in the opening phase of this nomination hearing, and it's the issue involving child pornography. I want to turn to that issue because it was raised multiple times, primarily by the senator from Missouri. And he was questioning your sentencing record in child pornography cases that do not involve the production of pornographic material. They're known as non-production cases. I wanted to put some context here. The senator from Missouri has in his tweets said of your position on this issue, "Judge Jackson has a pattern of letting child porn offenders off the hook for their appalling crimes, both as a judge and a policymaker. She's been advocating it since law school. This goes beyond soft on crime," the senator said. "I'm concerned this is a record that endangers our children." I thought about his charges as I watched you and your family listening carefully yesterday, and what impact it might have had on you personally to know that your daughters, husband, parents, family, and friends were hearing the charges that your implementation of this law, sentencing, endangered children. Could you tell us what was going through your mind at that point?
Thank you, Senator. As a mother and a judge who has had to deal with these cases, I was thinking that nothing could be further from the truth. These are some of the most difficult cases that a judge has to deal with because we're talking about pictures of sex abuse of children. We're talking about graphic descriptions that judges have to read and consider when they decide how to sentence in these cases. And there's a statute that tells judges what they're supposed to do. Congress has decided what it is that a judge has to do in this and any other case when they sentence. And that statute doesn't say, look only at the guidelines and stop. The statute doesn't say, impose the highest possible penalty for this sickening and egregious crime. The statute says, calculate the guidelines, but also look at various aspects of this offense and impose a sentence that is, quote, sufficient but not greater than necessary to promote the purposes of punishment. And in every case, when I am dealing with something like this, it is important to me to make sure that the children's perspective, the children's voices are represented in my sentencings. And what that means is that for every defendant who comes before me and who suggests, as they often do, that they're just a looker, that these crimes don't really matter, they've collected these things on the internet and it's fine, I tell them about the victim statements that have come in to me as a judge. I tell them about the adults who were former child sex abuse victims who tell me that they will never have a normal adult relationship because of this abuse. I tell them about the ones who say, I went into prostitution, I fell into drugs because I was trying to suppress the hurt that was done to me as an infant. And the one that was the most telling to me, that I describe at almost every one of these sentencings when I look in the eyes of a defendant who is weeping because I'm giving him a significant sentence. What I say to him is, do you know that there is someone who has written to me and who has told me that she has developed agoraphobia? She cannot leave her house because she thinks that everyone she meets will have seen her pictures on the internet. They're out there forever. At the most vulnerable time of her life, and so she's paralyzed. I tell that story to every child porn defendant as a part of my sentencings so that they understand what they have done. I say to them that there's only a market for this kind of material because there are lookers, that you are contributing to child sex abuse, and then I impose a significant sentence and all of the additional restraints that are available in the law. These people are looking at 20, 30, 40 years of supervision. They can't use their computers in a normal way for decades. I am imposing all of those constraints because I understand how significant, how damaging, how horrible this crime is.
It should be noticed as well that the cases which the senator from Missouri referred to yesterday all resulted in incarceration of some magnitude. In the one case, the Hilly case, I want to quote what you said on the record. This family has been torn apart, speaking to the defendant, by your criminal actions. You saw it on the faces of those women, you heard it in their voices, and the impact of your acts on those very real victims who are still struggling to recover this day makes your crime among the most serious criminal offense this court has ever sentenced. And you imposed a sentence of 29 and a half years on that defendant. So the notion that you look at this casually or with leniency, as the senator has said, your record belies that. And in fact, what we're dealing with here is an issue which even this committee and members on the committee have been loath to address again. The original law was written at least 9 or 10, maybe longer, years ago, and the quantity of material was relevant to the sentencing. And now that we have computer access to voluminous amounts of material, it has raised questions, has it not, within the judiciary as to the appropriate sentencing in today's circumstances. This was a question that was raised before the Sentencing Commission, was it not?
It was, Senator. The Sentencing Commission has written at least one report, it did when I was there, looking at the operation of this guideline. As you said, the guideline was based originally on a statutory scheme and on directives, specific directives by Congress at a time in which more serious child pornography offenders were identified based on the volume, based on the number of photographs that they received in the mail. And that made total sense before, when we didn't have the internet, when we didn't have distribution. But the way that the guideline is now structured, based on that set of circumstances, is leading to extreme disparities in the system because it's so easy for people to get volumes of this kind of material now by computers. So it's not doing the work of differentiating who is a more serious offender in the way that it used to. So the commission has taken that into account, and perhaps even more importantly, courts are adjusting their sentences in order to account for the changed circumstances. But it says nothing about the court's view of the seriousness of this offense.
Judge, there have been several news organizations that have taken a look at the senator from Missouri's charges, ABC News, CNN News, the Washington Post, and others, and have concluded that they are inaccurate and unfair to you in their conclusions. In fact, one writer has said they are meritless to the point of unacceptable levels. Nationally, in 2019, only 30% of non-production child pornography offenders received a sentence within the guidelines range, fewer than 30%. Between 2015 and 2020, in the D.C. District Court where you served, judges imposed below-guideline sentences in non-production cases 80% of the time for the reasons you've just explained. Judges in Missouri, the home state of the senator who has criticized your record, did so 77% of the time. One particular judge whom the senator supported to become a federal judge by appointment of President Trump, unfortunately, has 77% record. If I'm sorry, I'm going to make sure that this is accurate. Here it is. In the United States versus Klotz, Trump appointed Judge Sarah Pitlick, the senator's choice for the Eastern District of Missouri, sentenced an individual convicted of possession of child pornography to 60 months, well below the 135 to 168-month sentence recommended by the guidelines. She appears to have run into the same issue or same challenge that you have described here. So going forward, in terms of this issue, it seems that we at least share the burden by your interpretation as to define this statute in modern terms, in terms of technology as it exists today. Is that the way you see it?
Senator, Congress is tasked with the responsibility of setting penalties. Congress tells judges what we're supposed to do when we sentence. And what I'd say is that Congress has to determine how it wishes for judges to handle these cases. But as it currently stands, the way that the law is written, the way that Congress has directed the Sentencing Commission appears to be not consistent with how these crimes are committed, and therefore there's extreme disparity, as you pointed out. There are judges who are varying because our ultimate charge from this body is to sentence in a way that is sufficient but not greater than necessary to promote the purposes of punishment.
Judge Jackson, we've heard criticism from some about your previous work representing detainees at Guantanamo Bay. In fact, for years, we've heard criticisms leveled against lawyers who have provided Guantanamo detainees with legal representation. This criticism misses one critical point. The right to counsel is a fundamental part of our constitutional sentence system, even for the most unpopular defendants. I want to thank Senator Graham, who served as an Air Force lawyer for decades, for offering his perspective yesterday. He said, and I quote, "The fact that you're representing Gitmo detainees is not a problem with me," Senator Graham said. "Everyone deserves a lawyer. You're doing the country a great service when you defend the most unpopular people." And then Judge Roberts said during his confirmation hearing, it's a tradition of the American bar that goes back before the founding of the country that lawyers are not identified with the positions of their clients. The most famous example probably was John Adams, Chief Justice said, who represented the British soldiers charged in the Boston Massacre. This sentiment is shared by lawyers across the political spectrum. I want to give you an opportunity to address this issue because it applies not just to Gitmo detainees, but to your work as a public defender in terms of the wisdom, if acceptability of providing counsel in those cases, and what impact it's had on you personally in terms of your rulings on the bench.
Thank you, Senator. September 11th was a tragic attack on this country. We all lived through it. We saw what happened, and there were many defenses, important defenses, that Americans undertook. There were Americans whose service came in the form of military action. My brother was one of those Americans, those brave Americans who decided to join the military to defend our country. There are others of you in this body who have military service, and I honor that, to protect our country. After 9/11, there were also lawyers who recognized that our nation's values were under attack, that we couldn't let the terrorists win by changing who we were fundamentally. And what that meant was that the people who were being accused by our government of having engaged in actions related to this under our constitutional scheme were entitled to representation. We're entitled to be treated fairly. That's what makes our system the best in the world. That's what makes us exemplary. I was in the Federal Public Defender's Office when the Supreme Court, right after the Supreme Court decided that individuals who were detained at Guantanamo Bay by the president could seek review of their detention. And those cases started coming in, and federal public defenders don't get to pick their clients. They have to represent whoever comes in, and it's a service. That's what you do as a federal public defender. You are standing up for the constitutional value of representation. And so I represented, as an appellate defender, some of those detainees. In the early days, the legal landscape was very uncertain. This had never happened before, not only the attack, but also the use of executive authority to detain people in this way. And there were a lot of questions that the court was asking. The Supreme Court had taken a series of cases to try to understand what are the limits of executive authority, which is important. All of our liberty is at stake if we don't get it right in terms of what the executive can do. The Supreme Court has recently reaffirmed that the Constitution does not get suspended in times of emergency. And so lawyers were trying to help the court to figure out what the executive's power was in this circumstance. And as an appellate defender, I worked on the habeas petitions of some of these detainees. My petitions were virtually identical because we had very little information. Part of the issue at the very beginning of these cases was that most of the factual information was classified. So defense counsel were appointed to represent these defendants. We had no facts, and I was making legal arguments about the circumstances. That is what gave rise to my representation, and I would just emphasize that that's the role of a criminal defense lawyer. Criminal defense lawyers make arguments on behalf of their clients in defense of the Constitution and in service of the court.
Judge Jackson, those of us who read about the workings of the Supreme Court realize it's a close relationship among the justices. You've seen it personally as a clerk and as an attorney yourself. I'm going to close with one question here that comes to my mind. I was in the House of Representatives when the war on drug measure was passed 30 years ago or so. It was at the advent of crack cocaine. It scared the hell out of us. The notion of a cheap narcotic, highly addictive, destructive to mothers and their fetus, led us to impose a sentencing disparity between crack and powder cocaine that was unprecedented, 100 to 1. Our notion was to come down hard, make it clear that it was a federal standard, impose that standard, and stop the advance of crack cocaine. We failed from the outset. The price of cocaine, crack cocaine on the street went down and up instead of down. I'm sorry, I did that wrong, down instead of up. And the number of users went up instead of down. And we found ourselves in a position where we were filling the federal prisons with violations primarily for possession of crack cocaine, hundreds of thousands being incarcerated at that time. I came here to this committee in an effort to try to change it, negotiated a revision of that measure from 100 to 1 to 18 to 1 with Senator Jeff Sessions. It was passed by the committee, by the Senate, and by the House of Representatives and signed into law by President Obama. Then you on the Sentencing Commission had to consider what to do with these new guidelines coming from Congress. And you achieved a consensus. I think most people don't realize the Sentencing Commission is a pretty diverse group and very transparent. Could you close in the last minute or so and tell me about that effort to find consensus on an issue that controversial?
Yes, Senator. As you mentioned, the Sentencing Commission is a very diverse group of people who've been appointed by presidents of different parties by law. And at the time that I was on the commission, we had a range of people, judges from different backgrounds, who had different views about the criminal justice system, but we had a directive from Congress insofar as Congress had changed the penalties, as you mentioned, related to crack cocaine. And so we worked together to make a determination about whether or not the guidelines needed to change, and if so, whether or not to impose those changes retroactively in light of all of the evidence that you point out, all of the Congress's changes, and the need to avoid unwarranted sentencing disparities, which is exactly the charge that this body has given to the commission. And we worked together. We reached unanimous agreement that the change in the guidelines that was necessitated by the change in the statute should apply retroactively to people who had been convicted and sentenced under the prior regime, and then Congress followed shortly thereafter by making it a statutory change to apply those changes retroactively.
Thank you, Judge Jackson. Senator Grassley.
Thank you, Mr. Chairman. Welcome again to our committee. I got home last night about 8 o'clock. The first thing I heard was my wife's opinion that you did very good in your opening statement.
Thank you.
She didn't have anything to say about my statement. Also, besides the fact that we might have some votes on the United States Senate, just so you know I'm not being rude to you, I may have to go across the hall to Finance Committee on some issues with tariffs and down to the Agriculture Committee for some issues on rural health care. Do you believe, well, let me ask it this way. Do the First Amendment free speech protections apply equally to conservative and liberal protesters?
Yes, Senator.
Okay. Do you believe the individual right to keep and bear arms is a fundamental right?
Senator, the Supreme Court has established that the individual right to keep and bear arms is a fundamental right.
Could you tell me how you might go about deciding what a fundamental right is under the Constitution?
Well, Senator, I don't know that I can tell you that in the abstract in the sort of way that you may have posed the question. There is precedent in the Supreme Court related to various rights that the court has recognized as fundamental. The court has some precedents about the standards for determining whether or not something is fundamental. The court has said that the 14th Amendment substantive due process clause does support some fundamental rights, but only things that are implicit in the ordered concept of liberty or deeply rooted in the history and traditions of this country. They're the kinds of rights that relate to personal individual autonomy, and they've recognized a few things in that category, and that's the tradition of the court for determining whether something is fundamental in that way.
Okay. On another subject, kind of personal to me over a long period of time and about half of this committee, but it's a controversial issue even within this committee. I favor allowing Supreme Court hearings to be televised. What's your view on this? How would you feel about cameras in the courtroom, which about 40 or 45 of our states allow?
Well, Senator, I would want to discuss with the other justices their views and understand all of the various potential issues related to cameras in the courtroom before I took a position on it.
I think that's a fair answer at this point. I'm going to ask you about a bill that I got passed a long, long time ago. And it's something that at some level of courts, sometime the district court, sometime at the circuit court, and even once or twice at the Supreme Court, these courts tend to do damage to a bill called the False Claims Act. This bill has brought $70 billion of fraudulently taken money back into the federal treasury since it's been passed. And courts have weakened it, and then Senator Leahy and I usually find ourselves having to pass legislation to say to the courts, you got it wrong. In fact, there's a very controversial bill right now before the United States Senate on that very subject. It's fought fraud in the Department of Defense, healthcare industry, the pharmaceutical industry. $70 billion is pretty important. So when you get, if you're approved to be on the Supreme Court and the issue of false claims comes up, I hope you think of Chuck Grassley. It's one of the, well, and Leahy. Okay. The False Claims Act is one of the best tools that we have to fight against government fraud and to recover taxpayers' money. I've worked for decades to protect whistleblowers who shine a light on fraud, waste, and abuse in the government. So I'd like to ask you a couple questions. And I'm going to start with a former Attorney General, unnamed, once suggested that Ketam's suits were, in his words, patently unconstitutional, and another word he used was dangerous. He argued that it violated the Appointments Clause. So, understanding that you may get a case before you on the False Claims Act, but maybe this Appointment Clause is sound enough, you could answer, do Ketam suits violate the Appointments Clause?
So, Senator, I am not familiar with that
Could you answer,
representation.
Could you answer in writing then?
Well, I'd be happy to do whatever. I'm just trying to assess.
I'm sorry, I shouldn't have interrupted you.
No, that's all right. Sorry. I am trying to, I'm not familiar with the quotation or what the attorney may have said about them. I know that the Supreme Court has considered various Ketam actions and has issued opinions in the area and has not, at least to date, found them to be unconstitutional. But I don't know if that issue has been squarely presented to the court, and I would be loath to comment on it, just because if it's being litigated, it's something I wouldn't be able to address.
Let me, on the same subject, also, this former Attorney General also argued that Ketam suits also violate a broader separation of power principles. Can you tell me whether you think the president's constitutional powers are violated when private citizens are allowed to sue in the name of the United States? And that's what Ketam suits are all about, private citizens going to court.
Well, Senator, it is an important concern. There are statutes that do allow for the kinds of lawsuits that you are articulating. I am not aware of impediments to those, but again, you know, this is the kind of thing that may be litigated, and I would have to look, as I do, consistent with my methodology, at any arguments that are raised about the constitutionality or lawfulness of those actions.
Remember, in about all of these suits that involve the courts in making interpretations of the False Claims Act, most of them are brought by whistleblowers. And remember, the government would not even know about these fraudulent use of taxpayers without whistleblowers coming forth. And they ought to be given some credit for wanting the government to do what the laws say it ought to do and spend the money the way that the Constitution or that the Congress implies that that money be spent. I want to move on. At an event at the University of Chicago School of Law in 2020, you quoted Martin Luther King Jr., who dreamt of a time when, quote, the sons of former slaves and the sons of former slave owners would be able to sit down together at the table of brotherhood, end of quote. You talked about how quickly things in the country then changed, including the civil rights laws, over the next few years because of the civil rights movement. You added that, quote, less than a decade after Dr. King's words, that was the world that you inhabited. Dr. King hoped for a country where we would all be judged by the content of our character rather than our race. Do these quotes still reflect your views on this very important topic today?
Yes, Senator. In that speech, I talked about my background, my upbringing, the fact that my parents, when they were growing up in Miami, Florida, attended and had to attend racially segregated schools. Because by law, when they were young, white children and black children were not allowed to go to school together. And my reality, when I was born in 1970 and went to school in Miami, Florida, was completely different. I went to a diverse public junior high school, elementary school. And the fact that we had come that far was, to me, a testament to the hope and the promise of this country, the greatness of America, that in one generation, we could go from racially segregated schools in Florida to have me sitting here as the first Floridian ever to be nominated to the Supreme Court of the United States. So yes, Senator, that is my belief.
And I think that it's good that the country had an opportunity to hear what you just told us about your experience. I'm going to go to something that the chairman brought up, and I've written down the three steps you go through. No, another question, but also one that he brought up on court packing and your opinion. I heard what you said, and you said it should be a policy question, but I want to go to something in 2013 during your hearing to be a district court judge. Senator Coburn asked you whether you believed in the theory that the Constitution is a living document whose meaning evolves over time. You said no. In 2021, however, during your circuit court nomination hearing, you declined to answer the same question when asked why the answer to your question of 2013 and not in 2021. In written questions, you noted that you weren't a sitting judge. So please explain to me or describe for us the difference between ethical rules for sitting judges versus judicial nominees who are not already judges.
Senator, I don't know that there are ethical rules that are different. What I'll say is, with respect to my approach to judging, there is not a label, I think, that fits what it is that I do and how I've approached my role. As I mentioned to the chairman, I'm very acutely aware of the limitations on the exercise of my judicial power, and those limitations come in the form of adherence to the text. Assuming you even get to that stage of the process, that you have subject matter jurisdiction, you can reach the merits, then you are looking at the text, and I do not believe that there is a living constitution in the sense that it's changing and it's infused with my own policy perspective or the policy perspective of the day. Instead, the Supreme Court has made clear that when you're interpreting the Constitution, you're looking at the text at the time of the founding and what the meaning was then as a constraint on my own authority. And so I apply that constraint. I look at the text to determine what it meant to those who drafted it.
On this same subject, I want to point out a difference between you and a couple people that have sat on the Supreme Court. Justice Breyer said that a structural alteration of the Supreme Court motivated by perception of political influence can only feed the perception of political influence, that's my parenthetical, further eroding that trust. Justice Ginsburg also cited court packing as being quote unquote a bad idea. Court packing is creating new seats for political purposes for a president to appoint more judges. Do you agree with Justice Breyer and Justice Ginsburg that court packing is a bad idea? Before you respond, I'd like to say that you say this question should be left to Congress as a policy issue. I'd reiterate that sitting Supreme Court justices have spoken on that matter, so I don't think it'd be inappropriate for you to do if other people sitting there have said that it's a bad idea.
Well, respectfully, Senator, other nominees to the Supreme Court have responded as I will, which is that it is a policy question for Congress. And I am particularly mindful of not speaking to policy issues because I am so committed to staying in my lane of the system, because I'm just not willing to speak to issues that are properly in the province of this body.
Okay. Then I would interpret your answer, and you don't have to respond to this, but I think you're saying Breyer and Ginsburg should not have stated their views on that issue. During his opening statement yesterday, one member of this committee suggested that the Supreme Court has been bought by dark money groups. Do you agree that the Supreme Court has been bought by dark money groups?
Senator, I don't have any reason to believe that that's the case. I have only the highest esteem for the members of the Supreme Court, whom I hope to be able to join if I'm confirmed, and for all of the members of the judiciary.
Thank you for that answer. I'm going to go to international law. During an ABA panel on international law last year, Justice Breyer said that as a federal judge, quote, "You can't do your job properly," end of quote, without considering international law and, quote again, in some cases, and it's a growing number, end of quote, and I assume a growing number of opportunities to use international law. In 2018 op-ed, Justice Breyer said that, quote, "The best way to preserve American values may well be to take account of what happens abroad," end of quote. Under what circumstances is it appropriate to consider international law when interpreting our Constitution?
Thank you, Senator. I have nothing but the highest esteem and respect for my former boss, who I've spent the better part of the past couple decades calling my justice, having clerked for him. But I do think that the use of international law is very limited in our scheme and in our judging. There are certain cases in which it is relied upon where Congress directs or where the standards are such. The case involves a treaty, for example, and you have to interpret international law in order to be able to address it. But there are very, very few cases, I think, in which international law plays any role, and certainly not in interpreting the Constitution.
I think you probably have answered my next two questions, but if you say you have nothing to add, I would still want to ask the questions. Do you think it's appropriate to look to international law when interpreting enumerated and unenumerated constitutional rights?
No, Senator.
Which specific again, I think you've answered this, but I want to ask it anyway. Which specific constitutional clauses or rights has the Supreme Court held that can be interpreted by looking to international law?
I'm not aware of any that are properly illuminated by reference to international law.
Now I want to go to a question that Senator Durbin asked. I'll probably go a little more, but I remember when this is about your judicial philosophy, and you made 3 points, 3 steps you take to go through a case and apply the law, and you say your methodology is limited power and stay within your lane. I'd like to ask you, well, you've served on the district court for several years and spent 8 months on the DC circuit. During yesterday's opening statement, we heard a lot about the importance of judicial philosophy. In your own words, you've described that, so you don't have to go through that again with me. But if Congress writes a law that does not explicitly allow private parties to sue, do you believe that the federal courts have the authority to create implied causes of action? And I'd like to have you elaborate if you say yes to that.
I would say that as a general matter, no, Senator. I mean, our obligation as judges is not to create policy. And if Congress has enacted a statute that establishes a cause of action or restricts causes of action, then as a general matter, I don't think that courts can impose one. Now, you know, I'm saying generally because there may be circumstances that I'm not thinking of. I know that the Supreme Court has, in very narrow circumstances at times, discussed implied causes of action. But I think the charge of the judge is to impose the law as written.
There's 115 justices that serve before you if you are approved by the Senate. Is there any of them now or in the past that has a judicial philosophy that most closely resembles your own?
You know, I haven't studied the judicial philosophies of all of the prior justices. I will say that I come to this position, to this moment, as a judge who comes from practice, that I was a trial judge, and my methodology has developed in that context. I don't know how many other justices, other than Justice Sotomayor, have that same perspective, but it informs me with respect to what I understand to be my proper judicial role.
What aspect of your record as a judge do you believe have been the most important for the good of the country?
Well, I think that all of my record is important to some degree because I think it clearly demonstrates that I'm an independent jurist, that I am ruling in every case consistent with the methodology that I've described, that I'm impartial. I don't think that anyone can look at my record and say that it is pointing in one direction or another, that it is supporting one viewpoint or another. I am doing the work and have done the work for the past 10 years that judges do to rule impartially and to stay within the boundaries of our proper judicial role.
Let's go to immigration. Congress gave the Attorney General, quote, unquote, sole and unreviewable discretion to decide whether expedited removal would apply to, quote, an alien who has not been paroled or admitted to the United States. You decided a case called Make the Road, New York, where you seem to agree that Congress gave the Department of Homeland Security sole and unreviewable discretion to decide which illegal immigrants would be subject to expedited removal. But you still went on to review the department's decision. In fact, you issued a nationwide injunction blocking Department of Homeland Security from removing illegal immigrants who had been in the country for less than 2 years. In that hearing, you told us that if the text was clear, that ended the question. The law specifically says that Homeland Security, not the courts, was responsible for making the decision. Could you please explain why you believed a federal court could review something Congress called unreviewable?
Thank you, Senator, for allowing me to address that opinion and my analysis with respect to it. As you said, Make the Road was a case involving a challenge to expedited removal, which was a way in which Congress had given the authority to the Department of Homeland Security to make a decision about how to deport people who are non-citizens. Prior to the challenge that I heard, the Department of Homeland Security, since it received that authority several decades ago, had decided that people who are in this country for up to 14 days and are found within 100 miles of the border are subject to expedited removal. The challenge that I heard involved the department's sudden shift to a determination that expedited removal would be applied to anyone who was found anywhere in the country and who had been here up to 2 years. Importantly, the challenge was not about the actual determination. The challenge was about the procedures that the agency undertook to make that determination. And so the statute said, as you rightly pointed out, that the agency had sole and unreviewable discretion to decide. And in interpreting that, I took into account the language of that statute and the language of another statute that Congress has enacted to direct agencies with respect to the manner in which they exercise their discretion. So I said, and I believed, that sole meant that the Department of Homeland Security was the only agency who got to make this determination as to how many months a person should be in the United States. And unreviewable meant it was final. Once the agency decided, then there was no ability to review substantively their determination. And I should say that, importantly, the statute that Congress enacted gave the agency the discretion to make this determination between 0 and 24 months. There is a limit in the statute. It says Department of Homeland Security, you get to decide where between 0 and 24 months a person who's been in this country can be subject to expedited removal. So I read the statute. DHS gets the sole ability to make that decision. DHS makes that decision and it's final. What wasn't clear to me based on that language was whether Congress intended to preclude its procedural requirements for the exercise of agency discretion. And in the DC Circuit, there was precedent that indicated that even when Congress gives a great deal of discretion to an agency, procedural requirements may still apply. It is presumptive that the APA applies, meaning that an agency can't act arbitrarily and capriciously when it undertakes to exercise discretion. It has to do certain things in order to make the determination that Congress has given it. I looked at those statutes. Oh, I'm sorry.
No, no.
I looked at those statutes and I considered the canons of construction that say that statutes should be read harmoniously, that that as a court you're supposed to understand that Congress has directed, sometimes in more than one statute, what is supposed to happen. And so I read them together to mean that the court could still do what it almost always does in a case involving a challenge to the manner in which an agency makes its decision. And in fact, I thought, as I say in my opinion, that Congress intended for the APA to imply, because it had not excluded it, which it had done expressly in other parts of the INA. It had not excluded it here, and it made sense to require the agency to use its expertise. If Congress wanted the agency to act arbitrarily in picking a number, Congress could have done that. Congress said you can do it up to 24 months. It could have randomly picked a number, but it was giving it to the agency, I thought, and reasoned, precisely because it wanted the agency to use its expertise, to do its research, and to figure out what amount of time is sufficient. And so it was important, I thought, to lay that out in the statute, and I determined that both of those statutory directives of Congress should apply.
Thank you, Senator Grassley. Senator Leahy.
Thank you, Chair Durbin. Judge, congratulations again on your nomination to our nation's highest court. You're an impressive jurist. I hope the broader public sees that, and I've enjoyed the opportunity to meet your family here yesterday. And but I thought before I begin my questions, I was going to respond to something the junior senator from Texas said yesterday. He suggested the Democrats exacted a political agenda by opposing the nomination of then Judge Gorsuch to the Supreme Court. I kind of chuckle at that because, along with others, others repeatedly and clearly stated substantive concerns with Justice Gorsuch's nomination. I explained my votes on the record. There's no political agenda. I contrast that with Republicans' treatment of then Judge Merrick Garland. We're still waiting today for Republicans to explain on the record what kind of substantive concerns they had with Merrick Garland, that they blocked him for over a year and would not even allow a vote on his nomination, apparently because of a politically driven agenda. All I'm saying is let's make history this week, but let's not rewrite it. This is a historical time. Judge Jackson, one of the topics we discussed in our meeting was our respective experiences. You as a former federal public defender, myself as a prosecutor. As a federal public defender here in Washington, you were assigned to and then represented clients who couldn't otherwise afford a lawyer. One of the valuable lessons I learned as a prosecutor was this: for our criminal justice system to function properly, you have to have skilled, dedicated lawyers on both sides of the issue, both the prosecutor and the defense attorney. It's equally essential for judges to have a nuanced and a balanced understanding of our criminal justice system if we're going to have justice done. Now, it's really concerning, it's confusing that some view your background as a federal public defender as some kind of a liability. Those of us who have spent time in courtrooms know you have to have both the skilled prosecutor and a skilled defender. I believe it, in fact, I don't think of it as a liability. I think it's going to be a major asset to you, and I think it should be welcome on the Supreme Court. In perspective, if you're confirmed to the court, as I look back over, you're going to be the first former federal public defender on the court. You're going to be the first nominee since Justice Thurgood Marshall with a significant background in criminal defense. That's pretty impressive. So all of us should want that represented in the Supreme Court, because decisions on the Supreme Court can have a lasting impact on our criminal justice system. My question is this. I believe that your experience as a federal public defender has made you a better judge. How do you maintain impartial and balanced perspective in criminal and other cases? And I assume you would agree with that.
Yes, Senator. I think that experience in the criminal justice system, whether, as you say, on the prosecution side or the defense side, having actual experience is an asset as a judge. You understand the way the system works, and as a defense counsel, you have interacted with defendants in a way that, as a judge, at least as a trial judge, I thought was very beneficial. One of those ways is it helped me to develop a sense of the need to communicate directly with defendants. And, you know, it didn't change, I think, in any way the outcomes of the cases when I was a trial judge, but I understood from my time as an appellate defender that a lot of defendants go through the system and don't really understand it. And the problem with that, from our society's standpoint, is that when people go through the criminal justice system and don't have a good understanding, they tend to not take responsibility for their own actions. They tend to be bitter and feel as though the justice system has wronged them, and so while they're doing their time, rather than reflecting on the fact that this is the consequence that they have to face for actually committing a crime, instead of doing the work to rehabilitate themselves, they're, you know, focusing on how wronged they are, how victimized they feel. And so what I decided as a trial judge was that I was going to make sure that everyone who was in my courtroom, and especially the defendant, understood all of the procedures that we were going through, all of the steps. I spoke directly to them. I asked them, do you understand what's happening? Because I wanted them to know. And then, even perhaps more importantly, as I said about my child pornography cases, I focused on the harms of the behavior that was at issue. When I sentenced a defendant, I made clear in every case, here is the problem. This is what you've done. Here is the damage to our society. And I don't know that I would have done that if I had not been a criminal defense lawyer.
Well, and that's sort of what, you know, I was getting to, the fact that you have that experience. Also, it's obvious you don't get, as a public defender, you don't get the right to, you don't get to choose your clients. It's not like you're going out there picking and choosing. You're told you're going to defend this person, but they're given that right under the Sixth Amendment. And we all, you're a member of the bar or judge or public defender, you take an oath to uphold the Constitution. And the Sixth Amendment's a pretty important part of it, wouldn't you say?
Absolutely, Senator.
And it's also a pretty important part for indigent defendants. Is that not correct?
That is correct, especially for indigent defendants, because they are determined to not be able to afford counsel. And as you said, Senator, for a judge, it is crucial that you have arguments that are being made and presented on both sides of the issue. That is what allows for judges to reach just results in cases, and it's what makes our system so exemplary.
It also guarantees that our Constitution is going to be followed. I think it's important you went around with Senator Doug Jones, who's highly respected in the Senate on both sides of the aisle, but you got to meet other senators. I was delighted you came to spend time in my office, and you noted in your public remarks at the White House when you were nominated that your parents were married for 54 years, and both public servants in their own right. And they were proudly watching you being announced by the president, and I must admit, watching them the last couple of days, they're proudly watching you here, as have other members of your family. Your younger brother became a police officer, detective in Baltimore before serving the Army, two tours of duty in the Middle East, two uncles who served as police officers. So I'm not really surprised that you understand law enforcement. The National Fraternal Order of Police has expressed strong support for your nomination. In fact, in their letter dated February 25th, 2022, they said you have considered the facts and applied the law consistently and fairly on a range of issues. And they went on to say there's little doubt you have the temperament, intellect, legal experience, and family background to earn this appointment. And they added, we are reassured that should she be confirmed, she'd approach her future cases with an open mind, treat issues related to law enforcement fairly and justly. Chair Durbin, I'd ask consent that the letter from the Fraternal Order of Police be included in the record at this point.
Without objection.
Now, that's a statement from the largest law enforcement labor organization in the United States. What do you say to people who say you're soft on crime or even anti-law enforcement because you accepted your duties as a public defender?
Thank you, Senator. I would make, I'd make three observations in response to those critiques. The first is that as someone who has had family members on patrol and in the line of fire, I care deeply about public safety. I know what it's like to have loved ones who go off to protect and to serve, and the fear of not knowing whether or not they're going to come home again because of crime in the community. As you said, my brother patrolled the streets of Baltimore, and I had two uncles who were career law enforcement, including one who became the chief of police of the City of Miami Police Department in the 1990s. So crime and the effects on the community and the need for law enforcement, those are not abstract concepts or political slogans to me. The second observation that I would make is that as a lawyer and as a citizen, I care deeply about our Constitution and about the rights that make us free. As you say, criminal defense lawyers perform a service, and our system is exemplary throughout the world precisely because we ensure that people who are accused of crimes are treated fairly. It's very important to me in that capacity as a lawyer and as a citizen. Oh, I'm sorry. I was just going to say the third thing I would say is as a judge. As a judge, I care deeply about the rule of law. And I know that in order for us to have a functioning society, we have to have people being held accountable for committing crimes. But we have to do so fairly under our Constitution. As a judge who has to decide how to handle these cases, I know it's important to have arguments from both sides, to have competent counsel. And it doesn't mean that lawyers condone the behavior of their clients. They're making arguments on behalf of their clients in defense of the Constitution and in service of the court. And it is a service.
Well, I know in our conversation, I'd mentioned my own experience as a prosecutor. I wanted the best defense attorney on the other side because you want to make sure that as the trial went on, everything was done properly. And let's talk about Guantanamo Bay. It's been controversial, and we've had two presidents, one Republican, one Democratic, who said they wish it could be closed. But the fact is, individuals were detained there. The whole world was watching this. I know I heard from people I respect throughout the world asking questions about Guantanamo. And that's precisely the situation. We want our best and our brightest lawyers to step into the fray, however politically controversial. We have to make sure that we do not become unmoored from our core commitments to the rule of law, but that also, both in our own country and outside our country, people can see that we're following that. So you were in private practice when you took on these cases, uncharted legal waters, war. What principles drove you to get involved with cases in such a difficult time in Guantanamo Bay?
Well, thank you, Senator. And I do want to clarify, when I first started working on these cases, I was an assistant federal public defender. The Supreme Court in 2004 issued two opinions that began this group of cases and these issues. And this was in the wake of the tragic and terrible attack on this country in 9/11, and the executive's use of authority to detain enemy combatants at Guantanamo Bay. In 2004, the Supreme Court ruled that the executive did have the authority to make those detentions in one case, and then in another case, the Supreme Court ruled that anyone so detained could file a legal challenge. They had habeas rights, and as you know, habeas is in the Constitution. In 2005, I joined the Federal Public Defender's Office, and those cases started coming in. The requests from detainees asking for legal representation consistent with our constitutional scheme to have help to file their habeas petitions. This was very early in the days of these kinds of legal actions. There was a lot unknown about what these petitions could look like, what the arguments could be made and considered by the court, and perhaps most importantly, what the facts were related to any of these individuals, because almost everything was classified. So defense counsel was getting these people in with no information. I was in the appellate division of my office, and as an appellate defender, I worked on legal issues. I was paired with I was assigned by the federal public defender. I was an assistant federal public defender, and I was paired with a trial defender who attempted to do the fact gathering, who traveled to Guantanamo Bay. I never traveled there or anything like that. I worked on the law. And as you noted, the law was very uncertain. This was brand new. And people were trying to figure out what are the limits of executive authority in this context. We knew that the Constitution was not suspended.
even though we had this emergency. So what did that mean with respect to these individuals? I filed as a federal public defender. I was assigned to work on 4 cases, and I filed almost identical petitions, because what you're doing, especially when you have no facts, is just preserving legal arguments for your clients. That is consistent with what lawyers do. And then you mentioned private practice. So I went into private practice in, I believe it was 2007. And by that time, lots of private practices around the country had started taking on these cases, because there were lots of people who needed representation. And so pro bono practices were receiving requests, usually through nonprofits. And one of the individuals that I had represented as a defender ended up being assigned to my firm, unbeknownst to me. So I arrive at my firm, and the partners realized that this same person was someone that, according to the docket, I had previously represented, and they asked if I would review some of his materials and continue the representation. That was the only person that I represented in the context of my private firm who was a detainee. I worked on a couple of habeas briefs for judges and for a variety of nonprofits, including the Rutherford Institute, the Cato Institute, and the Constitution Project, who were all interested in making arguments to the Supreme Court that was considering these very novel legal issues.
You know, I sit here and I think of the 20 Supreme Court nominees I've gotten to vote on over my years here, and I think of the remarkable praise you got from the former Republican House Speaker Paul Ryan, whom most of us know well. He did mention his politics may be different than yours, but his praise for your intellect, for your character, for your integrity is unequivocal. That's powerful praise. And I think it goes to a really fundamental point, and that's this. One doesn't have to have the same political beliefs or ideologies as a judicial nominee to recognize their integrity and intellect. When I voted to confirm Chief Justice John Roberts of the Supreme Court, I cast that vote knowing very well that he and I would disagree on many policy and political issues. But I voted yes because I believed that he had what it takes to serve as an impartial, fair Chief Justice who would uphold the rule of law, and I want to take it out of partisan politics. Now, what would you say to people whose politics may be different than yours, like Speaker Ryan, who has endorsed you? What would you say to those people about your readiness to serve as an even-handed, unbiased Supreme Court justice?
Thank you, Senator. I would say that I am committed to serving as an even-handed Supreme Court justice if I'm confirmed by this body. And I have a record over the past decade that's precisely how I've treated all of my cases. And I've been serving in the District of Columbia, both as a trial judge and as an appellate judge, and we see some of the most politically contentious issues. My record demonstrates my impartiality.
Well, I'd go along with that because, and I watched this court. I used to go there as a young law student, sit in the back and just watch it. I continue to watch it. I see the chief judge of the federal district court, Judge Beryl Howell, who I was privileged to have her serve as my chief counsel on this committee, and learned from her then, I learned from her now. But I also, as a lawyer, I hear a lot of talk about reversal rates. Now, no judge goes without being reversed somewhere. If they're never reversed, they haven't heard many cases. But your time in the DC District Court, less than 2% of your more than 550 cases were reversed. Considering the fact that the DC Circuit reverses an average of 13% of the cases, it hears. You got a pretty good record, but what does a judge who's been reversed? What do they take from that reversal? What do they or what should they think about it?
Well, you obviously look at it very carefully. What it means is that a panel of judges who've reviewed what you determined for some reason has decided differently. And there are times when panels of judges decide differently because they are making a new statement about the law, or they're establishing a standard that had not previously been the case in the area. And so you learn, oh, this is a new standard now that I need to apply. There are times when you disagree, that people can disagree about the way in which the law works. And that's why we have panels, because people have judges can have different perspectives and in good faith reach different results. And so obviously when you're on the trial court, the Court of Appeals is binding, and they tell you, in this case, no, we're going to, the result is something different. And so you learn.
You know, anytime I had an opportunity to argue a case at an appellate level, I don't think I ever thought about who nominated or appointed the judges as before. I just want to know what I would think about their experience. And I would think about that when I made the argument. Now, I don't think I've ever had the opportunity to argue before anybody had your breadth of legal experience here. You served as a federal trial court, a federal appellate court judge for almost 10 years. You clerked at all 3 levels of the federal judiciary. You practiced law as a federal public defender in private practice, and I know we confirmed you as a member of the U.S. Sentencing Commission. This may seem like an easy question, but I just ask you that you've had such broad experience, but they're all different in a way. How does that shape your approach when deciding a case?
Well, thank you, Senator. As I mentioned at the beginning, I have a methodology that I apply when I'm deciding cases, and maybe my various experiences helped me to get to the point of understanding the importance of impartiality, staying in my lane as a judge, because the prior experiences were different roles in the system. Because I saw the different roles, I think I have a good appreciation of what it means to be a judge and the limitations on my own authority. The Sentencing Commission was a policymaking branch of the judicial branch that the commission and the commissioners developed sentencing policy. Congress delegated that authority to create the commission, and so they're doing the policy work, gathering data, making recommendations. That is totally different than the work that I do as a judge. Advocacy, on behalf of your clients, making critical arguments, the best arguments you can come up with, is a service to the court, but it's a totally different thing than operating as a judge. And so I think that having had those various experiences, I'm now really mindful of my role and limitations in the judicial branch.
Well, and the president referred to you as a proven consensus builder, and I think he was also thinking of your predecessor, Justice Breyer, in that regard. And I think over the years, how important that is, even in a body like the U.S. Senate. I see Senator Tillis here. He and I have worked together on IP issues. Senator Cornyn and I on freedom of information issues. Senator Grassley and I on other issues. Senator Graham and I on various issues. And usually, in the Senate at least, if you work across the ideological spectrum, you get better results. So let me ask you, how would you describe your approach to building consensus on cases related to issues like intellectual property that are less likely to break along traditional ideological lines?
Thank you. Thank you, Senator. One of the things that I was able to do when I worked on the Sentencing Commission was work with people who had very different perspectives than I did about the criminal justice system and come to consensus. It's very important, as you've said, to try to find common ground. And Justice Breyer was such a wonderful model, a role model for that kind of ability as a Supreme Court justice. It's something I learned from him, and something I tried to model in my work on the commission, that I try to model in my work as an appellate judge, and that I would model or do if I were confirmed to the Supreme Court.
Thank you, Chair Durbin.
Thank you, Senator Leahy. And now Senator Graham.
Thank you, Judge. Again, congratulations. I want to talk to you a little bit about family and faith, because in your opening statement, and the people who introduced you to the committee, there was very glowing praise of you as a person, a good friend. You have a wonderful family. You should be proud, and your faith matters to you. What faith are you, by the way?
Senator, I am Protestant.
Mm-hmm. Okay.
Non-denominational.
Okay. Could you fairly judge a Catholic?
Senator, I have a record of
I think the
fairly
answer would be yes.
judging everyone.
I believe you can. I'm just asking this question because how important is your faith to you?
Senator, personally, my faith is very important, but as you know, there's no religious test in the Constitution under Article 6, and
There will be none with me.
It's very important to set aside one's personal views
Yeah,
about things in the role of a judge.
I couldn't agree with you more, and I believe you can. So, on a scale of 1 to 10, how faithful would you say you are in terms of religion? You know, I go to church probably 3 times a year, so that speaks poorly of me. Or do you attend church regularly?
Well, Senator, I am reluctant to talk about my faith in this way just because I want to be mindful of the need for the public to have confidence in my ability to separate out my personal views.
Well, how would you feel if a senator up here said, your faith, a dogma, lives loudly within you, and that's of concern? How would you feel if somebody up here on our side said, you know, you attend church too much for me, or your faith is a little bit different to me, and they would suggest that it would affect your decision. Would you find that offensive?
Senator, I'm
I would if I were you. I found it offensive when they said it about Judge Barrett. The reason I ask these questions is I have no doubt that your faith is important to you, and I have zero doubt that you can adjudicate people's cases fairly if they're an atheist. If I had any doubt, I would say so. But the only reason I mention this, Judge, you're reluctant to talk about it because it's uncomfortable. Just imagine what would happen if people on late night television called you an effing nut, speaking in tongues because you've practiced the Catholic faith in a way they couldn't relate to or found uncomfortable. So, Judge, you should be proud of your faith. I am convinced that whatever faith you have and how often you go to church, it will not affect your ability to be fair. And I just hope going in the future that we all can accept that, and that Judge Barrett, I thought, was treated very, very poorly. So I just wanted to get that out. Let's talk about family. Do you know Janice Rogers Brown?
Yes, I do know her.
Okay, how do you know her?
She was a judge on the court that I now serve. We didn't overlap, and I'm struggling to remember whether I ever met her, but she was a judge on the circuit court.
Right, and you were a district court judge, is that right?
I was, but I don't know whether she had,
I think you were.
Retired at
Are
the
they in the
time.
same building?
they are in the same building.
Okay.
They are in
So
the
you
same,
really don't know her,
I know of her, yes.
okay? What do you know of her? What's her reputation?
I know that she's a very well-respected judge on my circuit.
Okay. And in terms of family, she was the daughter and granddaughter of sharecroppers. She was raised in Alabama under Jim Crow. Despite this adversity, she put herself through law school as a single working mother. That's pretty impressive, isn't it?
Yes, Senator.
Your background is very impressive. You seem to have a great family. If family mattered, we would not have done to her what was done to her here in the United States Senate. Do you realize that she was filibustered for 2 years when she was appointed to the D.C. Circuit?
I didn't know that.
Did you know that Joe Biden actively filibustered Janice Rogers Brown?
I did not know that.
Did you know that he told Face the Nation, if Bush nominates her for the Supreme Court, I can assure you that would be a very, very, very difficult fight, and she probably would be filibustered. Is that news to you, too?
Yes.
Okay. Now that you know that, how do you feel about it?
Senator, I can't speak to something that I just learned 2 seconds ago in your
Okay, fair enough.
conversation with me.
Fair enough. You're in the Black Law School Society, right? At
The
Harvard.
Black Law Students Association.
Okay, Black Law Student Association.
Yes.
You're a member at Harvard.
Yes.
And in sometime, the Mr. Jeffries thing, do you remember that whole dust-up? He got,
Only in preparation for this, and I think I was in college at the time. It was my senior year of college.
okay, so you weren't actually in the group when he was invited to speak?
I don't know which group invited him to speak. I was a black student at Harvard, both in the Harvard Undergraduate Black Students Association and the Harvard Law School Black
Right.
Students Association.
Do you remember going to a speech given by Mr. Jeffries? I think he's the uncle of Akeem Jeffries.
I did not go to a speech
Okay.
given by Mr. Jeffries.
Are you now familiar with the press reports about what Mr. Jeffries' views are?
Just in preparation for this.
Okay, and do you associate yourself with those views?
I do not, Senator.
As a matter of fact, he's been called by many as very anti-Semitic. He called you skunk who stink up the place. You don't agree with that, do you?
I do not, Senator.
And it would be wrong for me or anybody else to hold his statement against you because he spoke at some group you're a member of, right?
Senator, I don't have, yes, it
It would be, yeah, that's right. That's the right answer. I thought that was the right answer with Judge Alito. When they made a big deal about some group he was in that had views that he didn't agree with and tried to call him basically a racist, and found out that Senator Kennedy, God rest his soul, who beat the crap out of the guy for being part of some supper club that was actually in some organization called the OWL that didn't admit women. So I guess the reason I'm bringing all this up is it gives me a chance to remind this committee in America there are two standards going on here. If you're an African-American conservative woman, you're fair game to have your life turned upside down, to be filibustered no matter how qualified you are. And if you express your faith as a conservative, all of a sudden you're an effing nut. And we're tired of it. And it's not going to happen to you. But it just appalls me that we can have such a system in America, that if a conservative woman wants to stand out and say, I love my family just as much as you love yours, and my faith means just as much to me as it does you, that all of a sudden there comes some kind of weirdo. And a guy like Justice Alito, who's in the same type situation you're in, being in a group, doesn't agree with everything they do or what people may say at a meeting he didn't go to, all of a sudden they own it. You know, this stuff needs to stop. Our people deserve better respect, and I hope when this is over, people will say you were at least well treated, even if we don't agree with you. So now let's talk about Gitmo. Being a public defender, did you consider that rewarding?
Senator, yes, I did, because public service is very important to me. It is an important family value. It is something that now I've dedicated my career to.
Yes. And do you think it's important to the system that everybody be represented?
Absolutely, it's a core constitutional value.
You'll get no complaint from me. That was my job in the Air Force. I was a area defense counsel. I represented anybody that came in the door, whether I liked them or not. I did my best. Is that what you did?
Yes, sir.
Okay, good. Now, so the American people deserve a system where everybody's represented, where you like them or not, and anybody that takes up that cause, no problem with me. You're just doing your job, and I think you make our country stronger. But there's the other side of the story that never gets mentioned when I talk about Gitmo. The American people deserve a system that can keep terrorists off the battlefield. They deserve a system that understands the difference between being at war and a crime. Do you consider 9/11, you said, a terrible, tragic event? Would you consider it an act of war?
Yes, Senator.
Okay, I would too. I think it was an act of war by Al-Qaeda and associated groups against the people of the United States. So as you rightfully are proud of your service as a public defender, and you represented Gitmo detainees, which is part of our system, I want you to understand, and the nation to understand, what's been happening at Gitmo. What's the recidivism rate at Gitmo?
Senator, I'm not aware.
It's 31%. How does that strike you? Is that high, low, about right?
I don't know how it strikes me overall.
You know how it strikes me? It strikes me as terrible.
Yes, that's what I was going to say.
Okay, good. We found common ground. Of the 229 detainees released from Gitmo, of 729 released, 229 have gone back to the fight. Here's some of the notables. Former Gitmo detainee Zakir was named the interim defense minister of Afghanistan. I don't know exactly what his job is today, but during the transition, they made him the defense minister and he was in Gitmo. Of the 5 men we released from Gitmo as part of prisoner swap for Sergeant Bergdale, here's where they're at. Mohammed Fazal was appointed Deputy Minister of Defense. Noor was appointed Acting Minister of Borders and Tribal Affairs. Waziki was appointed as Acting Intelligence Director. Kerr, again, Acting Minister of Information, Culture, Defense. Omar was appointed as the new governor of the southeastern province of Khost. These were 5 people that we had in our control that are now helping the Taliban run the country. Would you say that our system in terms of releasing people needs to be re-looked at?
Senator, what I'd say is that that's not a job for the courts in this way, that
As an American, does that bother you?
well, obviously, Senator, any repeated criminal behavior or repeated attacks, acts of war, bother me as an American.
Well, it bothers me. While I will not hold it against you, nor should I, the fact that you represent Gitmo detainees, I think it's time to look at this system anew, folks. When 31% of the people are going back to fight to kill Americans and now running the Taliban government, we have gone wrong somewhere. Are we still at war?
So the AUMF, the authorization for military force, is still in effect. Congress has authorized the use of force against people in this way.
But do you personally believe that Al-Qaeda, ISIS-type groups are still at war with us?
I think, yes. I mean, I think
So we're still in a state of war with certain elements of radical Islam to this very day?
I believe that's documented, yes.
Okay. Now, what's the process to determine whether one's an enemy combatant under our law?
Well, I believe that the executive branch makes an assessment of whether or not someone is taking up arms against the United States somewhere in the world related to all of this.
Okay, so it's an executive branch function to determine whether or not this person qualifies as an enemy combatant
Well, I believe that they make a
under current law.
Under current law, I believe that determination is made by the executive branch, and the person is detained, and then the question becomes whether they are able to bring some sort of legal challenge to that
They have a habeas
determination.
right.
Yes.
Okay, so the law is that the executive branch determines if you're an enemy combatant, and under our law, you can appeal that decision to a federal court through habeas. Is that correct?
I believe that's correct.
Okay. Is it your view that we can hold enemy combatants as long as they're a threat to the United States?
I believe that's what the Supreme Court has determined.
Okay. Did you argue that that should not be the case before in an amicus brief?
I'm trying to think. I had 2 amicus briefs that I worked on, or 3 technically, but 2 different cases.
Well, we'll have another visit tomorrow. So
Yes.
Go back and check.
Yes.
I'm pretty sure that in your brief, you argued that the executive branch should not have the ability to hold an enemy combatant indefinitely. You need to try them through some process or release them.
Yes, Senator, as you were talking, my clients, the Cato Institute, the Rutherford Institute, and the Constitution Project, made that argument and asked me to draft their brief.
Yes. Well, do you agree with that argument?
Senator, my responsibility was to make my clients' arguments, and as a nominee to the Supreme Court, that's the kind of issue. The Supreme Court did not address that issue. They, in fact, the case became moot.
Did you organize an effort to get 20 judges to file a brief with the Supreme Court on this issue?
Not on that issue, no, Senator.
On another issue?
Yes, Senator.
Okay. Did you actively go out and recruit 20 judges to help you file a brief on another issue regarding law of war detention?
Not technically.
What do you mean by that?
What I mean is that I was at Morrison and Forster, which was my law firm, in the Supreme Court and appellate group. One of the partners at Morrison and Forster was a former federal judge who wanted to make this argument and who said,
I have former federal judges who are friends of mine who would like to join with me to make this argument. So I worked with her, the partner at my firm who was a former federal judge, to make.
So it was her idea to get former judges to write this,
Yes.
not yours?
Yes.
And you just helped in the implementation of that idea?
So, Senator, as a member of the Supreme Court and appellate group in a law firm, that is the practice.
Right, now I'm asking you,
Amicus practice, yes.
It wasn't your idea, it was somebody else?
Yes.
Okay. So, now, there are people still held at Gitmo today. Do you understand that?
Yes.
Okay. What system is in place regarding their future?
I am not aware of the system right now. I'm not sure exactly what you mean.
Well, let me tell you what it is.
Yes.
There's a periodic review process made up of an interagency where they go through the files of these folks and they determine whether or not they still present a threat to the United States or the world at large. And I think it's 6 months, maybe a year. But that goes on, at least on an annual basis. And if there's a determination that this person still represents a threat to the United States, they're continued to be confined. That's the way the system works. Are you okay with that?
As a policy matter, Senator, I'm not speaking to my views. That's my understanding is that the periodic review system is an executive branch determination of whether or not they're going to continue to hold people that they.
Does that make sense to you as a way to deal with these detainees?
Senator, I'm not in a position to speak to the policy or the discretion of the executive branch regarding how they're going to handle detainees.
The reason I mention it is because in one of the briefs you argued that the executive branch doesn't have that option. That if you had had your way, the executive branch could not do periodic reviews about the danger the detainee presents to the United States. They would have to make a decision of trying them or releasing them. Is that not accurate?
Respectfully, Senator, it was not my argument. I was filing an amicus brief on behalf of clients, including the Rutherford Institute, the Cato Institute, and the Constitution Project, who.
When you sign on to a brief, does it not become your argument?
It does not, Senator. If you are an attorney and you are representing a client in amicus.
Is that your position when you were in private practice? I mean, you sign on to this brief making this argument, but you say it's not your position. I mean, why would you do that if it's not your position? Why would you take a client that has a position like that? Now, this is voluntary. Nobody's making you do this.
Oh, Senator, I would refer you to the same sorts of statements that Chief Justice Roberts made when he came before the committee, which is that lawyers represent clients.
I get that. I'm not holding the client's views against you. The people you represent at Gitmo, they deserve representation. But this is a amicus brief where you and other people try to persuade the court to change policy. The policy I described is a periodic review. If the court had taken the position argued in the brief that you signed upon, we'd have to release these people or try them, and some of them, the evidence we can't disclose because it's classified. You're putting America in an untenable position. This is not the way you fight a war. If you tried to do this in World War II, they'd run you out of town. We hold enemy combatants as long as they're a threat. There's no magic passage of time that you got to let them go. So my question is very simple. Do you support the idea, did you support then the idea that indefinite detention of an enemy combatant is unlawful?
Respectfully, Senator, when you are an attorney and you have clients who come to you, whether they pay or not, you represent their positions before the court.
I'm sure everybody at Gitmo wants out. no, I got that. This is an amicus brief, and I just don't understand what you're saying, quite frankly. I'm not holding it against you because you represented a legal position I disagree with. I mean, that happens all the time. I'm just trying to understand what made you join this cause. And you say somebody hired you, but did you feel okay in adopting that cause? I mean, when you signed on to the brief, were you not advocating that position to the court?
Senator, as a judge now,
Okay.
in order to determine the lawfulness or unlawfulness of any particular issue, I need to receive briefs and information, making positions on all sides. And
No,
with
I got what a judge is all about. Listen, I'm not asking you to decide the case in front of me right here. I'm asking me to explain a position you took as a lawyer regarding the law of war, and I am beyond confused. I know what you said in your brief. Whether I agree with it or not, it's not the point. I just want you to understand that it's important for all of us to know where you were coming from. If that brief had been accepted by the court, it would be impossible for us to fight this war. Because there's some people going to die in jail in Gitmo and never go to trial for a lot of good reasons, because the evidence against them is so sensitive we can't disclose it to the public. That we're not charging them with a crime. What we're doing is saying that you engaged in hostile activities against the United States, that you are an enemy combatant under our law, and you will never be released as long as you're a danger until the war is over or you're no longer a danger. That's the difference between fighting a crime and a war. Did you ever accuse in one of your habeas petitions the government of acting as war criminals for holding the detainees? That the holding of the detainees by our government, that we were acting as war criminals?
Senator, I don't remember that accusation, but I will say that
Do you believe that's true? That America was acting as war criminals in holding these detainees?
Senator, the Supreme Court held that the executive branch has the authority to detain people who are designated as enemy combatants for the duration of the hostilities. And what I was doing in the context of the habeas petitions at this very early stage in the process was making allegations to preserve issues on behalf of my clients. A habeas petition is like a complaint that lawyers make allegations.
You know, I've been a lawyer too, but I don't think it's necessary to call the government a war criminal in pursuing charges against a terrorist. I just think that's too far. I don't know why he chose those words. That's just too far. But we are where we are. So let's talk about the nomination process. Have you ever had any interaction with a group called Demand Justice?
No,
Directly or indirectly?
no,
Have you ever had interaction with a group called American Prospect?
no.
Do you know anything about Arbella? Is that the right term? Have you ever heard of a group called Arbella?
I've heard of a group that I think is Arabella or something like
I think
that.
you're right. Not
Yes.
Arabella. Yeah. Do you know anything about them? Have you had any contact with them?
No,
Okay. In your nomination, did you notice that people from the left were pretty much cheering you on?
a lot of people were cheering me on,
That's
Senator.
true. That's true. Did you know that a lot of people from the left were trying to destroy Michelle Childs? Did you notice that?
Senator, a lot of people were supporting various people for this nomination.
So you're saying you didn't know there was a concerted effort to disqualify Judge Childs from South Carolina because she was a union-busting, unreliable Republican in disguise?
Senator, I was
I'm a sitting judge. I was
Yeah,
focused on my
well,
cases.
the answer is no, I didn't know that.
No, I didn't know that.
Would it bother you if that happened?
Senator, it is troublesome that people are or were doing things related to,
I think
The
that's the
nomination?
best way to say it. People have a right to speak out and pick the person of their choice. But all I can say is that if you miss the fact that there was an organized effort, well, here's President Biden has only a certain amount of political capital for keeping his party united. If he needlessly angers progressives on this SCOTUS pick, that could create all sorts of problems for him down the line. Jeff Hauser, revolving door projects. Let's see. I just got so many quotes. It's difficult to imagine someone with a record like Judge Childs winning votes from criminal justice advocates like Senator Cory Booker, even Dick Durbin. Childs' experience is nothing like the diversity of experience that the Biden administration has championed. Let's see. Picking her, Childs, would demoralize the base, side with corporate America. The fact that Lindsey Graham is vouching for her should give the White House pause. Our revolution, Joseph Gervangi, or whatever his name is, I'm sorry about that, Joseph. He's Bernie Sanders' PAC director. You didn't know that all those people were declaring war on Judge Childs?
Senator, I did not.
Okay. Well, no, I'm not saying you did. You said you didn't know. I'll take it at your word. But I am saying that what is your judicial philosophy?
So I have a methodology that I use in my cases in order to ensure that I am ruling impartially and that.
So your judicial philosophy is to rule impartially?
No, my judicial philosophy is to rule impartially and to rule consistent with the limitations on my authority as a judge. And so my methodology actually helps me to do that in every case.
So you wouldn't say that you're an activist judge?
I would not say that.
Okay. So we'll have 20 minutes more later on, but here's what I would say. That every group that wants to pack the court, that believes this court is a bunch of right-wing nuts that are going to destroy America, that consider the Constitution trash, all wanted you picked. And this is all I can say, is the fact that so many of these left-wing radical groups that would destroy the law as we know it declared war on Michelle Childs and supported you is problematic for me. Thank you.
Thank you, Senator Graham. Let me mention a few points here. Congressman Jim Clyburn was a strong supporter of Michelle Childs, and now I believe he is publicly supporting your nomination. And Michelle Childs has been nominated by President Biden to be a circuit judge, and she will be considered by this committee as quickly as possible. On the issue of Guantanamo, there are currently 39 Guantanamo detainees remaining. The annual budget for Guantanamo is $540 million per year, which means each of these detainees is being held at the expense of $12 or $13 million per year. If they would be incarcerated at Florence, Colorado, the Supermax prison, federal prison, the amount would be dramatically less. Since 9/11, nearly 1,000 convicted in the United States on terrorism charges. Since 2009, with the beginning of the Obama administration, the recidivism rate of Guantanamo detainees released is 5%.
Mr. Chairman, according to the Director of National Intelligence, is 31%. Somebody is wrong here. If you're going to talk about what I said, I'm going to respond to what you said. If we close Gitmo and move them to Colorado, do you support indefinite detention under the law of war for these detainees?
I would just say I'm giving the facts. And
The answer is no.
I want to make sure that it's clear. The 31% you referred to goes back to the year 2009? 2000.
What does it matter when it goes back to? We had them and they got loose and they started killing people.
Well, I could just say that.
If you're one of the people
suggest-
killed in 2005, does it matter to you when we release them?
Suggest that a president of your own party released him in
I'm suggesting the
Creating that
system has
danger.
failed miserably, and advocates to change this system, like she was advocating, would destroy our ability to protect this country. We're at war. We're not fighting a crime. This is not some passage of time event. As long as they're dangerous, I hope they all die in jail if they're going to go back and kill Americans. It won't bother me one bit if 39 of them die in prison. That's a better outcome than letting them go. And if it costs $500 million to keep them in jail, keep them in jail, because they're going to go back to the fight. Look at the friggin' Afghan government. It's made up of former detainees at Gitmo. This whole thing by the left about this war ain't working.
Let me also note that Larry Thompson, who served as Deputy Attorney General under President George W. Bush, Oren Kerr, Special Counsel, Viet Den, who served as Assistant Attorney General for Legal Policy in the George W. Bush administration, John Bellinger, and former D.C. Circuit Judge, Solicitor General, and Independent Counsel Ken Starr were also prominent conservative lawyers signing a letter defending attorneys who represented Guantanamo Bay detainees. I don't believe that we should associate that activity as being inconsistent with our constitutional values. We are going to at this point recognize Senator Feinstein and then take a break after she has completed her questioning. Senator Feinstein.
Thank you very much, Mr. Chairman, and I just would like to compliment the witness. I think you're doing very well, and as you can see, this is a bit of a tough place. So, Judge, one of the issues that I often discuss with nominees, particularly to the Supreme Court, is the issue of abortion. I've asked the three most recent Supreme Court nominees about this issue, and so I'd like to discuss it a bit with you today. In 2017, I asked Justice Gorsuch about this during his confirmation hearing. I asked him to expand on a comment he had made about his belief that precedent is important because it adds stability to the law. In response, Justice Gorsuch reiterated his belief that precedent is important because, and I quote, once a case is settled, that adds to the determinacy of the law, end quote. He also stated that Roe has been reaffirmed many times. I also spoke with Judge Kavanaugh about this issue in 2018. I asked him whether he believes that Roe was settled wrong, and if so, whether it was correctly settled. Justice Kavanaugh said that Roe, quote, is settled as a precedent of the Supreme Court, end quote. He said that Roe, quote, has been reaffirmed many times over the past 45 years, and most prominently, most importantly, reaffirmed in Planned Parenthood v. Casey, end quote. And he described Casey as having the value of a precedent on precedent, end quote. I most recently spoke about this issue with Justice Barrett in 2020. I asked her whether she agreed with Justice Scalia's view that Roe was wrongly decided. She committed to, quote, obey all the rules of stare decisis, end quote, if faced with the question of whether to overrule Casey. She said she had, quote, no agenda to try to overrule Casey, end quote. So here's the question. Do you agree with Justice Kavanaugh that Roe v. Wade is settled as a precedent? And will you, like Justice Barrett, commit to obey all the rules of stare decisis in cases related to the issue of abortion, end quote?
Thank you, Senator. I do agree with both Justice Kavanaugh and Justice Barrett on this issue. Roe and Casey are the settled law of the Supreme Court concerning the right to terminate a woman's pregnancy. They have established a framework that the court has reaffirmed, and in order to revisit, as Justice Barrett said, the Supreme Court looks at various factors because stare decisis is a very important principle. It provides and establishes predictability, stability. It also serves as a restraint in this way on the exercise of judicial authority, because the court looks at whether or not precedents are relied upon, whether they're workable, in addition to whether or not they're wrong, and other factors as well. So I agree with both of those statements that you read.
Well, let me add one to that, and then we'll move on. I'm particularly interested in the case of Roe v. Wade. Roe was decided by nearly 50 years ago, and it's been reaffirmed over a dozen times since then. So my question is this: does Roe v. Wade have the status of being a case that is a super precedent? And what other Supreme Court cases do you believe have that status?
Well, Senator, all Supreme Court cases are precedential, they're binding, and their principles and their rulings have to be followed. Roe and Casey, as you say, have been reaffirmed by the court and have been relied upon. And reliance is one of the factors that the court considers when it seeks to revisit, or when it's asked to revisit a precedent. And in all cases, the precedents of the Supreme Court would have to be reviewed pursuant to those factors, because stare decisis is very important.
Thank you. If you are confirmed, you would be one of only 2 justices who has also served on a federal district court, the other being Justice Sotomayor. In your 8 years as a trial judge on the D.C. District Court, you wrote nearly 600 opinions and presided over 9 jury trials and 3 bench trials. As you know from your service on the district court, it's important for appeals courts, and especially the Supreme Court, to be clear in their decisions. The clarity is necessary, as you well know, for trial judges to effectively do their job and properly apply legal precedents that are fair and consistent. As a district judge, you were responsible for applying precedent from the Supreme Court and the courts of appeal to your case. And now as a judge in the D.C. Circuit, you're drafting those precedents. Your experience as a trial judge is one of your most significant assets. And I just want to add a personal comment. This is a tough place, and you are handling it very well. And I appreciate your directness and think that's important. Here's a question. I have 2 related questions. How did you make sure that you were properly applying the relevant precedents as a district court judge? And if you're confirmed to the Supreme Court, what would you do to make sure your opinions are clear so they could be applied correctly by district courts?
Thank you, Senator. As you noted, in my time as a district court judge, I had the opportunity to apply precedents that were handed down by the Court of Appeals and the Supreme Court. The district court is bound by the law as stated by those other tribunals, and I was very focused on making sure that I found the right precedents and applied them faithfully. As I mentioned, with respect to my methodology, part of the process is receiving information from the parties in a case. And the parties write briefs, and in most cases, they identify the precedents that they at least believe are applicable. And then the court does its own legal research as well to determine whether all of the relevant cases have been identified. And then you look to see whether there's anything that directly controls, and if it does, that's your answer. In many cases, the precedents might be a little bit different in certain ways, and you are assessing the parties' arguments and determining within your proper role whether what the appellate courts have said provides the law of decision for the case. But what's important, as you've mentioned, is the clarity by which courts of appeals and the Supreme Court need to operate, and so that the lower courts can actually follow the precedents. And I'm very conscious of that, as you said, as someone who has had to follow precedent, and I would think carefully about that and use my communication skills to ensure that the precedents are clear so that lower courts can follow them.
Thank you. I'd like to discuss quickly a letter this committee received in support of your nomination from the International Association of Chiefs of Police. And as you know, this is the world's largest professional association of law enforcement leaders. And the letter states, Judge Jackson has several family members in law enforcement, and we believe this has given her a deep understanding of and an appreciation for the challenges and complexities confronting the policing profession. During her time as a judge, she has displayed her dedication to ensuring that our communities are safe and that the interests of justice are served. And so, Mr. Chairman, I'd like to put this letter in the record, if I may.
Without objection.
Thank you. I understand that your brother served with the Baltimore Police Department for several years. So here's the question. How, if at all, has having several family members in law enforcement impacted your understanding of the law or your approach to your judicial service?
Thank you, Senator. Some of my earliest memories, in addition to my father at the kitchen table with his law books, were of my uncles. Two of my uncles were career law enforcement, and one was a detective, uniformed detective. One was a City of Miami Police Department officer, patrol officer for a long time before he became the chief. And I remember very well, we would go to my grandmother's house on Sundays, and she would make a big dinner for our family, and my uncles would sometimes come off of their shifts. So I see in my mind their uniforms coming in, and they would always, they'd be carrying their weapons, and they'd take them off and put them way up high on the china cabinet so the kids couldn't get to them. And I remember feeling very proud of them and the service that they provided. And I think it's probably what led my brother, who is 10 years younger than I am, to decide that after he graduated from college, he would want to also be in law enforcement. So I'm very familiar with law enforcement, the important service that they provide, the perils of being out on the street, protecting and serving, and having a family that cares about you and worries about your safety. And so this is not something that is unfamiliar, and I'm very gratified by the support of the group that you mentioned and other law enforcement groups as I go through this process.
I joined this committee in January of 1993, and a few months later, we considered the nomination of Ruth Bader Ginsburg to the Supreme Court. Justice Ginsburg's confirmation made her only the second woman to ever serve on the Supreme Court, after Justice Sandra Day O'Connor. So we have come a very long way since then, though still not far enough. Women now make up about 35% of active judges on the federal district bench and 37% of active judges on the federal appeals courts. Judge Jackson, if confirmed, you would become the 6th woman to ever serve on the Supreme Court. You would join Justices Sotomayor, Kagan, and Barrett on the bench. This would be the nearest we have ever come to gender equity on the Supreme Court. There would be 4 women on a court with 9 justices. So I have my own thoughts about why gender balance is important on our nation's courts. But I'd really like you to tell us all, what are your thoughts on what it means for our country to have women serve in meaningful numbers on the federal bench, and in particular, what it would mean to have 4 women serving on the Supreme Court for the first time in history.
Thank you, Senator. I think it's extremely meaningful. One of the things that having diverse members of the court does is it provides for the opportunity for role models. Since I was nominated to this position, I have received so many notes and letters and photos from little girls around the country who tell me that they are so excited for this opportunity and that they have thought about the law in new ways because I am a woman, because I am a Black woman. All of those things people have said have been really meaningful to them. And we want, I think, as a country, for everyone to believe that they can do things like sit on the Supreme Court. And so having meaningful numbers of women and people of color, I think, matters. I also think that it supports public confidence in the judiciary when you have different people, because we have such a diverse society.
Well, I just want to say thank you very much. This is often a hard place, and how you go through those hard times, I really think, is the most important thing. And it's pretty clear to me that you go through hard times by holding your head up high and doing well. So I thank you very much.
Thank you, Senator.
Thank you, Senator Feinstein. We're going to take a break. Let's take 15 minutes starting now, and then we'll return to more questions. We'll have a lunch break later this afternoon, in the earlier part of the afternoon.